We're working very hard with all of our partners, law enforcement, prosecutors, other interested folks, to have a common agenda of public safety proposals for the legislature each year. It doesn't mean we all share all of the same priorities, but it means to the extent that we're on the same page on it, let's speak with one voice. We've been able to do that this year, and I think the results, knock on wood, the legislature's not done yet, but it looks very promising. The result is going to be some substantial strengthening in some of our statutes related to child sex crimes. So we are, for example, the legislature, both houses have approved, and I think the conference committee is likely to agree, a proposal to extend the statute of limitations for certain violent sex crimes committed against kids. The idea being that you want to decrease the chances that perpetrator can prevail simply by running out the clock and hoping a kid doesn't disclose in a timely manner. That was an idea brought to us by a detective in Wyandotte County. I thought it was an outstanding idea, and we've been able to make that part of the agenda. We have several other provisions related to sort of enhancing the toolbox of prosecutors and cops around the state with respect to investigating and prosecuting that category of crimes. We also will have, if the budget goes as we hope, again, both houses have approved it, for the first time in the modern history of the state of Kansas, maybe in the entire history, I haven't gone back and looked over the whole thing, we will stand up a capacity at the Kansas Bureau of Investigation to investigate crimes against children. A specialized unit whose focus it is to investigate crimes against kids. Now, you've got great capacity in the metro area on that. They do in Wichita as well, for the Exploited and Missing Children's Unit. But there are many parts of the state where that specialized expertise is very difficult to sustain in a very small budget, in a very small community where these crimes are infrequently caught and prosecuted. I would also mention we had this year a recommendation that was widely shared to kind of beef up some provisions in our domestic violence statutes. Again, I think this is one that probably should have done a long time ago, but for whatever reason, it just never quite made its way to the top. The legislature has approved, and I believe the governor has now signed into law a proposal that we brought forth out of this sort of shared agenda decision-making that will authorize courts to issue keep them apart orders, no contact orders, restraining orders for up to the lifetime of the people involved. Now, that's not appropriate in every case, but it is appropriate in some. And we just didn't think it made any sense to require, for example, a victim of domestic violence to have to go back to court on a regular basis and give the offender a rehearing simply to extend an order that's already in place. I look forward to defending what the legislature enacts. And we have tried in good spirits and also in all sincerity to follow that rule. We are in the process of defending a series of statutes enacted by the legislature last year, all of which have some connection to the broader policy debate on abortion, though they're not necessarily abortion specific. One relates to the relationship between insurance coverage in a base policy versus rider coverage for certain services. One relates to the legislature's authority to set priorities in the distribution of federal Title X funds. We think the legislature has that discretion, and we think they properly exercised it. That's under litigation now. One relates to the legislature's authority to set health standards and regulations for clinics, including but not limited to abortion clinics. So we're defending that as well. Those have been a little more vigorously contested. Obviously, there are political, philosophical debates surrounding that. That's great. That's not our role. Our role is to defend the law as it was enacted, and we are giving it our absolute best defense that we can. I'm very optimistic about where we're headed on that. Finally, let me close on the healthcare litigation. I wanted to close here because once I get going on this, it's hard to stop. We won't go too long. You know, in many ways, the granddaddy of them all, in terms of abuse of federal authority, was the enactment of the Affordable Care Act. Bottom line is that folks on the other side, led by this administration, want this debate now, the legal debate, to be framed up the same way the policy debate was framed up for years leading up to the ACA's enactment. And in the same way it will be framed up again once we're done with the legal piece of it. I mean, one way or the other, this policy debate isn't over. Whether the act stands or the act falls, there are still significant healthcare policy and financing issues that our policymakers are going to have to wrestle with. The other side, led by the President's administration, want the current issue to be just part of that broader continuum. It's all about how we're going to provide health care coverage to people who need it. We all agree with that, don't we? I mean, surely in the United States of America in the 21st century, you ought to have not only access to health care, but there ought to be a system to pay for it, avoid cost shifting, and all those things. That's what they want it to be about. The problem is we don't think that's what it's about. Yeah, I've taken to using the line, and it's I don't intend it to be offensive, it's just intended to sort of make the point crisply. You know, Congress has to color within the lines when it's drawing whatever picture it draws. we're not in a dispute about the picture Congress has drawn. We're not in a dispute about their desire to fix the healthcare system, whatever that may mean. We are in a dispute from the legal side because we think they colored outside the lines. The lines, of course, are the limits on federal authority established by the United States Constitution. President Reagan, with the support of the people, started to appoint justices who had a more limited view of the role of the federal government. And over time, because of those appointments, we've started to see the court again assert that there are limits. They're extreme limits. I mean, this is not, we're not talking about Articles of Confederation, chaos versus extreme control. We're way at the other end of the spectrum. The court said there are some limits. That's what we're litigating in the